Hey guys, it's Kathy. I hope you're doing well. No intro this morning or outro. It's too happy. This is not a happy case. This is horrific. But it's a roller coaster. You start out believing something and then you believe another, and you don't really understand anything until the judge speaks at the end. When the judge speaks at the end, she tells us everything that we should have known from the beginning. But this is what I got for today, guys. Thanks for coming out to the special stream. I appreciate it. Today's our day off. Oops, I almost ended the stream instead of press play.
Or we go into arguments by counsel, correct?
Correct.
Okay, so we will go ahead and have her take the witness stand, please.
State Court Adriana Silva.
Ms. Rich, you may proceed when you're ready.
Good morning, Ms. Silva.
Good morning.
So we are now at the point where the judge is going to determine sentencing for Ms. Malad, Mr. Young. We have heard your testimony about exactly what happened, but I want to talk about more how this affected you in the aftermath.
Of course.
How did this all affect you physically, not only at the time, but in the time afterwards?
The physical impact this has had on me has, to this day, physically impacts my life. The discomfort I feel from my tailbone being deformed now and my back pain. I have scars that will remain on my face for the rest of my life, and as well as a scar on my life from this incident. It has impacted me to the point where I struggle functioning on a daily basis. I struggle with sleeping on a daily basis, and it's been very hard to get back to my real life.
Now, you mentioned that. I want to touch on it more. You said you have a scar on your life. Can you talk to us about how this has affected you emotionally and physically?
Absolutely.
Or emotionally, mentally, sorry.
That's okay. Emotionally and mentally, everything that I used to do prior to this incident, I did with hope, free will, joy, happiness, and everything that I do in my life now, I have to question it several times. I have to create backup plans for my safety as well as my children's safety. And it's impacted my life in every way, emotionally, mentally, and physically.
Now, when this happened, obviously you reconnected with Ms. Malad and trusted that this was going to be kind of reconnecting. How has this affected your trust level in people?
I don't trust anybody. I have cut off anybody that I ever had communication with previously, that being friends that I grew up with since I was a child. I cut off all of my family because I don't trust anybody, and it's just my kids and I.
Now, I think maybe during your deposition you talked about just not really being able to get into any kind of counseling or therapy. Is that still the case?
I am looking into it again. I was, when I lived in Arizona, I was signed up for a lot of therapy and counseling sessions. However, I couldn't follow through with that because I don't even trust professionals anymore, and I question everything.
Now, I want to talk a little bit about your children, Lorenzo and Amias.
Yeah.
To remind us, how old were they when this happened?
Amias was 2 years old and Lorenzo was 4 years old.
And I think you mentioned during your testimony that just because of their ages and speech capabilities, neither of them would be able to come in and tell us exactly what they saw or what they heard or anything like that.
Yeah, unfortunately.
Did you notice changes in your children after the fact?
Absolutely.
Did the children see your injuries?
They did.
Can you talk to us a little bit about the differences you saw in your children after September 23rd?
When my children first saw me after the hospital, they were so scared of me. They wouldn't come by me. They wouldn't come near me. My 4-year-old has severe autism and he doesn't speak at all. And there were times when I would be sleeping from being on my pain medication and he would randomly come to the room and he would just rub my face and just try and show me that he was there for me. And my 2-year-old Amias was so scared of me, he wouldn't come by me. And after the fact, he struggled ever since with nightmares. And my children, they act completely differently now. They struggle with sleep, they struggle with the nightmares. And my 4-year-old, he's incredibly, incredibly protective of me, even with the state that he's in.
And were these, the night terrors, the sleeping issues, were those present before this attack at all?
No.
If these defendants were out of custody, would you be in fear for your safety?
Absolutely.
What else would you like the judge to know before she decides what the sentences are in this case?
I can't even have social media anymore because the videos of the attack were posted publicly, as well as my name posted publicly. This wasn't just an incident that happened inside of a duplex with me, Fred, and Tara.
Yeah. I was going to search for the videos that she's talking about until I saw the rest of the hearing. We don't need to see them. We don't.
This was something that went completely public, as well as my name. I was publicly humiliated. I have people that try to reach out to me and talk to me about the videos they've seen. And this has not been, it hasn't been easy. It hasn't been easy at all. I struggle with even leaving the house to go to the store because I don't want to run into people that know me. I stay inside all day.
Thank you. I have no other questions.
Thank you, Mr. Ring. Any questions for Ms. Silva?
No, Your Honor.
Mr. Dillon, any questions for Ms. Silva?
No, Your Honor.
Thank you, Ms. Silva. You may resume your seat in the audience. Thank you.
Thank you.
And one thing that I should mention for purposes of the record, that the court did have the opportunity to review the sentencing memoranda that were tendered by the parties. The state of Indiana had tendered also some additional exhibits that the court viewed in chambers prior to sentencing. Counsel, I don't know who would like to go first. I will defer to counsel how you wish to address this.
Your Honor, we can go.
Okay, Mr. Dillon, you may proceed.
Thank you. Your Honor, we would note that on the PSI for Mr. Young, he can make a statement out, just so I'm.
Absolutely, yep.
So on the PSI for Mr. Young, that he has no serious criminal history. He does have some misdemeanors out of state, that he was mostly traffic related. His risk factors and his IRAS scores, except for the one section which we pointed out earlier, were low. In addition to that, his statement, and he will speak today, his statement indicates that he does have some remorse as to the incident, and that he does regret the things that happened. And he stated that he did feel sorry or feel very bad that these things happened specifically to Ms. Silva. Your Honor, with his criminal history being what it is, we understand that these convictions are serious convictions. But we would argue that this was part of one criminal episode. And based off of that, Your Honor, we would ask that Mr. Young be sentenced to, and given his criminal history, no prior felonies, we would ask that Mr. Young be sentenced to a term of imprisonment, not above 9 years for each count, which is the advisory, and that those sentences be run concurrently, and that the court would suspend some of that on probation. The PSI does indicate that probation could be appropriate after a term of incarceration, so that some of that 9 years be suspended on the court's order of probation.
Thank you, Mr. Dillon. Mr. Young, is there anything that you'd like to say on your own behalf?
Yes, ma'am. I would like to say to the victim, Adriana, that as my utmost condolences to what happened to her that night.
And can we maybe move the mic? It's kind of awkward.
Okay, once they move this mic, a high-pitched, scratchy, squealy, terrible noise happens. And it also happens a little bit when she talks too. So I am going to mute part of it. You can't hear what he's saying during that part. It only lasts for a few seconds.
And it would be, Mr. Jordan. Go ahead.
I was saying that the victim in this case had my utmost. So, once I'm a bad person, I just got caught in a bad situation. So, a lot of positive things I was doing in the world as far as taking care of my kids, and trying to maintain a business, and in my house. I'm
Never met her before.
Often, just trying to do things to live life myself. So, thank you.
Thank you. Does the state wish to do arguments after both defendants have finished their portion, or do you wish to go ahead and make arguments now on Mr. Young's matter?
From the state perspective, it makes sense for us to just do it all at the end.
I think that would make sense from the court's perspective also. Mr. Young, arguments on your client's behalf with respect to sentencing.
Yes, Your Honor, what I'm anticipating doing is first getting some information from Ms. Willett, and
You
then
may.
make an argument if that's acceptable
Sure.
to the court. Okay, Tara, go ahead and state your full name.
Tara Lynn Malott.
All right, now Tara,
All right. So we just heard from the victim. Then we heard from her attacker. Now we're hearing from her other attacker. All right. It was a couple that attacked this woman. The man that we just heard from, sort of, we didn't really hear him. Never met her before in his life. The woman, however, went to school with her. Hasn't seen her in decades. Had a grudge on something that happened in middle school, I think. Maybe high school, but I think it was middle school. And is still angry about this, whatever it was that happened.
what I wanted to do is get a little bit more information from you with respect to the personal relationships. The PSI that we've reviewed documents that you have 4 children. Is that correct?
Yes.
I'd like to give the court a little bit more information about your children. Now, please tell the court the name of your oldest.
Zeke Coulser,
And how old is Zeke?
10 years old.
Who is Zeke's father?
Trenton Coulser.
Now, as you have been incarcerated with respect to this offense, there have been CHINS cases that have been filed with respect to your children. Is that correct?
Yes, that's correct.
Is there a CHINS?
We talk about CHINS cases a lot. Well, they do in this hearing, which I never heard before. So it's a CPS case.
Case that is currently pending with respect to Zeke.
Yes.
And at the present time, who is Zeke placed with?
Trenton Coulser.
Now Trenton is your ex, is that correct?
Yes.
Now, if I understand correctly, that was an abusive relationship. Is that also correct?
A very abusive relationship.
And at the present time, have you been allowed to have any contact with Zeke during the period of time that you've been incarcerated?
I have had a couple video visits with him. Other than that, my ex, he's not so friendly, so he doesn't really answer the phone.
Okay. So you've only talked to him on a couple of occasions via video visit, is that correct?
Yes,
Now, is that Chin's case scheduled to close?
yes.
When is the date for closure?
November 6th?
And at the present time, do you know what the permanency plan is?
No,
The only thing you know is that he is placed with your father or with his father, and you do not have a amicable relationship. Is that correct?
that is correct. And he doesn't want to keep Zeke. So it's up in the air where Zeke would go.
He's indicated that he does not want to keep him in his custody for the long term.
Yeah, he doesn't want to keep him in his custody for the long term because he doesn't even want our child.
Now, your second child is Eli Kuzar, is that correct?
Yeah, Eli Coulter.
Coulter, thank you. And that is also Trenton's child?
Yes,
Now, does Eli have some special needs?
yes, he's autistic and nonverbal,
How old is Eli?
4 years old.
Prior to your incarceration, was he receiving any sort of services?
Yes, speech therapy.
And is there a Chin's case that is pending with respect to Eli?
Yes,
And is that also scheduled for closure in November?
yes,
Is his present situation even more tenuous than Zeke's situation?
yes.
Can you explain to the court where he's placed and some of the issues surrounding the placement?
Eli is placed with my aunt and uncle, and they don't want to keep him there because of his autism. He's not fitting in well in their home. He's been with me his whole life since he's been born. He is also Trenton Coulter's kid, but Trenton doesn't want him due to his autism and the fact that he's a rape baby from Trenton Coulter. So he has no communication with Trenton at all.
And your aunt and uncle have unequivocally stated that they are not planning to keep him for the long term, is that correct?
Yes, they do not want him for the long term.
In terms of your understanding of what will happen in November if you are not in a situation that you are able to care for Eli, where will he go?
He will go with complete strangers into a different foster home.
There's not a relative that would be available for placement, is that correct?
No, none of them want to deal with his autism.
And has he continued to receive services for his autism during the time that you've been incarcerated?
Yes, he goes to Lighthouse Autism Center from 8 a.m. to 4 p.m. Monday through Friday. And sometimes he has an autism teacher that comes on the weekends to my aunt and uncle's house.
Now, because of his limitations, is it fair to say that you have not been able to have any sort of meaningful visitation with Eli during the time you've been incarcerated?
Yeah, because a video visit, like, but like Eli knows I've been there since Eli's been born, so he knows how to communicate with me to show me what he wants and needs.
Is it fair to say that the information you've received is that Eli's behavior has deteriorated since your incarceration?
Yes.
And in what way?
He doesn't communicate.
All four of her children, and I think both of the victims' children were in the apartment or house or whatever that night.
With them at all. He goes and sets off to the side. He doesn't, the only person that he'll walk up to is his little sister. He doesn't have anything to do with my aunt and uncle. He like stays completely away from them. And like when I'm video visiting him, he's like glued to the phone. Like, and they like have made the comments like, he doesn't even, like, if they come near him, he walks away from them. He
just isn't able to connect.
yes.
I want to turn your attention to your third child. Can you please tell the court his name and age?
Drake Honeycutt, and he's 3.
And who is Drake's father?
Jeffrey Honeycutt.
And my understanding is that you and Jeffrey were recently, your divorce was finalized. Is that correct?
Yes.
Was that, again, an abusive relationship?
Yes, it was.
All right.
Yeah.
Go ahead.
He actually went, like, when I finally had gotten him out of my household, he had went to jail for beating me in front of all 4 of my children, dragging me through the house and strangling me.
Now, Drake is placed with his father, is that correct?
Yes.
And is there a Chins case that is open with respect to Drake?
No.
So from the department's perspective, permanency has been achieved by a change of custody to Mr. Honeycutt, is that correct?
Yes.
Has he allowed you to have contact with Drake?
No.
When's the last time you were able to speak to Drake?
September 20th of 2024.
And it's fair to say that with the department or the DCS case closed, that there is absolutely no mechanism available to you to force any sort of contact. Is that correct?
Yes.
And you don't believe that he is willingly going to allow for any sort of video visit, telephone visit, or in-person visit if you're incarcerated, is that correct?
No, I would have to go through the court system and do that because he's a very controlling person and he will do anything manipulative. He's just that type of person.
Now, your final child is Maisie, is that correct?
Yes.
And how old is Maisie?
Maisie just turned 1.
And who is Maisie placed with?
Mikey and Cindy, my aunt and uncle.
So the same relatives that Eli is placed with, is that correct?
That's correct.
All right. And is Maisie's Chins case still open?
No,
And why has that case been closed?
because Mikey and Cindy filed for guardianship of Maisie to get her out of the system.
But as you indicated a few minutes before, they are not willing to do the same as it relates to Eli, is that correct?
Yeah, they won't do the same for Eli because Eli's autistic and they don't want to deal with his autism.
So at the present time, have your children been allowed to, other than Maisie and Eli, have they had contact amongst their siblings? You know, are they able to see each other?
No, the only way they will be able to see each other again is if I'm out of here. Because Trenton and Jeffrey, they won't correspond with each other. They won't reply back to my aunt and uncle. Jeffrey doesn't want Drake to have anything to do with his siblings. And none of them get along. Like, due to the fact that Cindy and Mikey are my aunt and uncle, and they were both abusive relationships, they don't want my other children around Jeffrey or Trenton. So it's just the only way my kids would get to see each other is with having me home.
And I understand that Maisie's very little, other than limitations because of her age. Has there been additional difficulties with your ability to have any sort of visitation with Maisie?
Yeah, because the only thing she can literally say is mama and dada right now. Like, she can't have a full-on conversation because she's 1 and her attention span isn't there because she's a baby.
So Tara, other than the information that we've provided the court with respect to your children, is there anything else you would like the judge to know about this offense or what you are asking her to consider for sentencing purposes?
I am truly sorry that this situation happened. There was way too much to drink that night. Like, I'm not a drinker. There was way too much to drink that night. And I am so sorry that this happened to Adriana. Like, it should have never happened. Everybody had way too much to drink. And it's a crazy situation that literally should have never happened. And I'm just so sorry it even happened.
I don't have any additional questions, Your Honor.
Thank you. Ms. String, arguments?
Your Honor, this is a case where, I think that there's a real stark contrast between an aggravator that is an extremely significant aggravator and a mitigator that's an extremely significant mitigator. I have reviewed the enumerated list that the court can consider under 3538-17.1, and I listed in my sentencing memorandum some of the factors that I believe are significant for the court to consider with respect to mitigators. I know the state's going to speak in more depth about aggravators, so I'm not going to embellish on that, but I'm not disagreeing that there are certainly aggravators present in this case, I'm aware. But from a mitigating standpoint, I think that the absence of any significant criminal history is very indicative. The only conviction that Ms. Millett has is the misdemeanor OWI. Pretty close in time to these events, and I think that speaks to a couple things. As she's indicated that she has been in a series of relationships that
Indicates she's a liar because she just said a minute ago she really doesn't really drink that much.
involve abuse. The current relationship with Mr. Young was one that was also characterized by abuse, and I think that is something that she has struggled with. I think that alcohol had become, to some degree, a coping mechanism for her, and as she indicated, she was not a regular drinker, and I think the evidence that was introduced at trial demonstrates that there was an incredibly high amount of alcohol consumed on the evening in question. I think that would speak to the fact that it would be extremely beneficial for her to have some substance abuse counseling to address that. The other thing I thought was significant about the mitigators that the court can consider is the question of whether or not the circumstances that led to these events is unlikely to reoccur. I believe that that's demonstrated in a couple of different fashions. One is her IRAS is very low. She is at low risk to reoffend. Second thing is that I talked to Tara about this was almost a perfect storm of events in the way that, it was what appears to be a very chance encounter that they met up. Things came together that, Ms. Silva came to Elkhart County on the evening in question. There was a lot to drink, and for whatever reason, things completely spun out of control. And I know that that's a very simplistic representation of what happened, but it certainly paints a picture of circumstances that are not likely to repeat.
That's just really just not what happened at all. You want to know how I know? He videoed it. He videoed everything they did to her. So no, it didn't just accidentally spin out of control. Yes, honey, my girlfriend's pregnant, honey. I know we're married, but I accidentally fell down on top of her while we were both naked. It doesn't just happen like that.
Themselves, particularly if there is, again, some addressing the issue of the alcoholic beverage intake and through the substance abuse counseling. I think that Ms. Millett would respond affirmatively to, some sort of treatment. I think that there are treatments that would be available through either community corrections or probation that could address not only the anger issues, but also the substance abuse issues. The other point, and that was the reason I wanted to take the testimony I did with respect to subsection 10 of the statute, is that the imprisonment of Ms. Millett will result in undue hardship, not only to her, but most significantly to her dependents. I don't think that I've ever been involved in a case where there is a more stark presentation of hardship for dependents involved. And quite frankly, Your Honor, I don't know if this court would make this comment. I've heard other judges make the comment with respect to, well, Ms. Millett made her choices.
So this is another reason that you don't know yet that this is not just an accident because they accidentally got drunk. The victim lives in Michigan. This is Indiana. they invited her and her children to Indiana so that they could do this. This was not like I bumped into her at the grocery store and we thought, nope.
And she wasn't thinking about her kids at the time the choices were made. And I always struggle with that comment because we are talking about a statute that enumerates mitigators and acknowledges that this is not an all inclusive list. And so the fact that the legislature has deemed it appropriate to enumerate hardship to dependents as a factor that the court has to place weight on, I always think that there is a diminishment of the significance of that mitigator if it's dismissed merely that, well, the defendant really wasn't paying attention to that fact at the time these events occurred. And like I said, I don't know that that's necessarily a comment you would make, but I did want to say that I believe this is a mitigator that has particular emphasis because it was enumerated in this statute. We are talking about 4 children that have not had contact with each other and have had little to no contact with their mother throughout the incarceration. 2 of the Chin's cases have been closed, and so there is literally no judicial oversight that can compel any sort of participation with Ms. Millett. And, quite frankly, just in my own experience with clients that are placed in the Department of Corrections, unless you have a parent or guardian that is willing to actually make the drive down to a facility to try and create a situation where there is face-to-face visit, it's just not going to happen. She could certainly try to go into the underlying custody cases and compel that, but the odds of that happening in any sort of a successful fashion are slim to none. We have got children that not only are isolated from their mother, but from each other. They are in 3 separate placements right now, and I think the most troubling child to consider is Eli, because you are talking about a 4-year-old child that is autistic, whose only continuity was his mother, and his mother has been taken away. I'm sure that the level of understanding in terms of what is happening to Eli is non-existent, and I think it is going to create a complete shutdown, and quite frankly, it makes me sick to think about him being stripped away from family and his sister and being placed with strangers, and that's exactly what's going to happen in November. And I don't say this lightly. I understand that what Tara and her family is going through pales in comparison.
I wonder how he would feel about a whole bunch of cats. I wonder if I can drive to Indiana and scoop him up in November.
Comparison to what Adriana Silva has went through, and I am not trying to minimize her experience in any way. When I am making these comments, I'm not trying to say, hey, this is more important, and so, forget everything Ms. Silva says. I'm not trying to suggest that. What I am trying to suggest is that when you consider the most significant aggravator and you pair it against what I believe is the most significant mitigator, I do believe there is a balance. And that is what I am asking the court to consider for sentencing purposes. Obviously, we have got an advisory sentence of 9 years on these offenses. And as the research that I've submitted to the court indicates, you are at complete discretion with respect to consent.
I'm going to spoil alert. She doesn't get 9 years. So she could get more, she could get less. I'm just telling you, she does not get 9 years.
Consecutive or concurrent, and the placement that is available to you. I would suggest, Your Honor, that an appropriate sentence would be 9 years on each of these counts. I would suggest it would be appropriate to run them consecutive. However, what I am asking the court to consider is that the majority of those 18 years, and I know that what Tara wants is that all of that time be placed on community corrections. We've talked about that at great length. But I also understand what the court has to consider with respect to the state and Ms. Silva's perspective. I know what she wants and I know why she wants it. It is my suggestion, Your Honor, that if you could think about the hardship that her children are going to suffer with any prolonged period of incarceration, I certainly think that the duration of what we are talking about in terms of imprisonment versus community corrections, these services that could be available through a community corrections placement, the very, very low probability of these circumstances ever repeating themselves. And obviously, punishment. There is always a punitive aspect to any sentence that's imposed. The punishment is going to be profound with respect to these convictions and the limitations placed on Ms. Millette, whether it is a DOC sentence or a community corrections sentence. And so I don't believe that there is any diminishment of the serious nature of these offenses if the court were to consider a community corrections placement. And that's what I'm asking you to do. Thank you.
Thank you. Ms. During, I have not looked at the Chin's petition, but I do have it pulled up in front of me.
I have no objection, Your Honor, if you want to look at that.
Thank you.
Oh, mistake.
Right, I believe that we are, oh, I'm sorry, Ms. Millette, is there anything else that you
Honey, your job was to object to that one. You don't want the judge to read that, dear.
wanted to say on your own behalf?
Yes, I'm just so sorry that the situation happened. There was way too much to drink that night, and none of this should have even happened. It should have been a good night of reconnecting with an old friend. Nothing should have went as far as what it did into that. I'm sorry, and it's not something that would ever repeat ever again.
Yo, my lying ass exes said I'm sorry 20,000 times better than that for things they were never sorry for, lady.
And I just really hope that you take into consideration house arrest, because my kids are the ones, I know Adriana suffered a bad situation that night, but my kids are suffering a lot too. Like my 4-year-old, like if I'm not home in November, my family wants it.
So we are going to find out what happened that night, but we are not going to find out what happened to that night in minute detail, but we're going to figure out what happened that night. Her tailbone is permanently disfigured. So that we won't hear later. If you don't remember that she said that, you won't remember. So that's why I said it again.
Thank you. Arguments from the state, please.
Thank you, Your Honor. The state does not believe it's being dramatic when it says it cannot overemphasize the level of danger that these two pose to others. There is a major community safety component to this case. These two really did not know Ms. Silva, and the only issue between all of them was some kind of fight from middle school between Ms. Malala and Ms. Silva. If these two could act with such depravity to someone that they don't know very well, the question begs, what could they do to someone else? Someone else they don't know as well, or someone maybe they do know over, quite frankly, any perceived slight. So the likelihood that this could happen again is actually quite high, in the state's opinion, given the specific facts of this particular case. And I'm not going to go through the whole brief again. I know the court has read it, but there are a few points that I want to bring up, because really, I also cannot overemphasize the brutality of this attack and the dehumanization of Ms. Silva. She was not treated like a person. She was not treated as someone with their own life and dignity. She was treated like garbage and a punching bag. It was horrifying to witness. And the state also cannot overemphasize just how much this has affected Ms. Silva based on her testimony today, physically, emotionally, mentally, how it's affected her kids. These two defendants ultimately gave Ms. Silva a life sentence because this is something that she will carry with her forever. So it's not necessarily a matter of revenge or retribution. There is a punitive part to it, but it's really a matter of justice for Ms. Silva and everything that she went through and continues to go through. we have two people here today who genuinely seem to believe as though they've done nothing wrong, or it's Ms. Silva's fault, or if they did do something wrong, it really wasn't that bad. With Mr. Young, he testified today, he said, quote, "What happened to her?" referring to Ms. Silva. He did not say what I did. I'm sorry for what I did, and that's a huge lack of acceptance of responsibility. Same thing with Ms. Malat. In her pre-sentence investigation report, she referenced that Ms. Silva was, quote, "acting weird." And then today, Ms. Malat said, "I'm so sorry this happened." That passive voice is very, very telling of the mindset of these two. Ms. Malat did not say, "I'm sorry for what I did." She tried to say she's not a drinker, but has an OWI offense a few months prior to that. Mr. Young's comments about Ms. Silva, she should have never come over. The victim blaming in this case is really, quite frankly, just offensive and really doesn't take into account Ms. Silva's significant physical and psychological injuries. There was also a point that there is a lack of criminal history, but there is criminal history there. And the state also takes the position that if this was, in fact, these two defendants' first major crime they've committed, that's just as concerning because the switch can flip just so dramatically. We saw the cell phone video footage of what Ms. Silva went through, and it was horrendous. Ms. Malat was providing many mitigating factors today, but she wasn't in the physical care of her children when this occurred, and it's terrible that she's put her children in this position. It's awful. But really, it is because of Ms. Malat and her actions. It's similar to almost any family law case where there are no good options for a child and the court is forced into a position of trying to pick the least worst option for these children. And that's a similar position to what the court has to face today. But quite frankly, the risk Ms. Malat poses to others in the community, when you balance that, the state believes that that mitigator just doesn't hold as much weight. Ms. Malat also pointed several times to her own victimization. And as a victim of physical assault, it is beyond the state's comprehension why Ms. Malat would subject a practical stranger to such a violent attack. Our court is a court that handles cases of domestic violence and of sexual assault. And I don't know if any of the victims that we've come across have committed a crime quite like this one. So it goes beyond what Ms. Malat's history is. And that's the same thing with substance abuse. We have tons of people who come through Elkhart County criminal justice system with substance abuse issues. But the substance abuse is completely different than the extreme violence that we witnessed in this particular case. And really, at the end of the day, the state provided evidence to this court where Ms. Malat was repeatedly calling Ms. Silva a liar over and over and over again. She lied. When the other caller was saying that Ms. Silva lied, Ms. Malat agreed. She is not sorry for what she's done whatsoever. The state also points to this with Mr. Young, especially his attitude towards women. Again, he didn't know Ms. Silva at all. He did not have that middle school history with Ms. Silva, but he tried to rape her. Mr. Young listed Shayla Taylor as his fiance in his pre-sentence investigation report, but the evidence came out that she is, quote, slut bitch in his phone. The level of delusion and detachment from reality that these two have exhibited is so concerning. And looking at the case, had the neighbors not intervened, this would be a very different charge and probably in circuit court. There's just no way about that. And again, I do not think I'm being melodramatic. So when we look at this, and again, what the state has referenced in its sentencing memorandum, this is a balance of the aggravators and mitigators. So it's not like one mitigator takes away an aggravator. It's not really one for one. It's putting everything on different sides of a scale and just seeing what that weight is. So that is why the state is asking for 32 years for Ms. Malach, 36 years for Mr. Young, because we truly believe that just with the depravity of this case and the danger that they pose, every possible day they can be incarcerated, they really do need to be incarcerated for the safety of this community. I'm going to turn it over to Mr. Leong now, who has handled a lot of the research as far as double jeopardy, consecutive and concurrent sentences.
Thank you, Mr. Leong.
Thank you, Your Honor.
Okay, two things real quick. The cat moved it, but don't worry, I'm going to fix it very, 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 very soon. And number two, the prosecutor's about to get up now. And He's about to go into all these cases for the judge to prove his point, his case. And it gets a little bit, teeny bit boring, only for a few minutes, unless you like to hear about law and cases. And then it'll be over. I didn't even know it was the prosecutor the first time I watched this, because I was trying to keep a hold of what he was saying, and I didn't do really good. No, the cat did not. Why would the cat do that? How would the cat do that? All the cat did was scroll the page up a little bit. So all we see is the bottom part of the courtroom. But very, very, very shortly, I'll fix it. I'll look over, I'll see what the cat did, and I'll fix it.
Mr. Ring has largely conceded this point, so I'm going to mostly tailor my my argument to sort of to respond to the brief from Mr. Young's attorney, Mr. Dillon. The response from the defense from Mr. Dillon largely ignores sort of that tripartite analysis that's prescribed under Waddle and AW. I won't go through the entirety of the state's argument again because I know that you have read the
No, I wasn't fully engaged. I was part listening, and he's like, I won't go through that again. The state wants this and that. Every time he said that, I thought he was Mr. Young's attorney, and he was saying that, well, the state wants this and that and that. No, he's talking about himself.
Random, but Mr. Dillon has argued that because the offenses committed by his client took place in the same place and in what he refers to as a very close time frame, that a concurrent sentence would be appropriate. I think that jettisons 2/3 of the Waddle test. The state acknowledges that under sort of the first prong of the Waddle test, whether or not the statute expressly permits double punishment, that doesn't really apply to our situation. But looking at phase 2, which instructs the court to apply the included offense statute, I do believe that based on how these offenses were charged, in the charging information on its face, there really isn't an argument that there's even an ambiguity that these offenses are essentially lesser included of each other. The factors that are relevant to our case from phase 2 of the Waddle test are whether it was established by proof of the same material, the offenses were established by proof of the same material elements, or less than all of the material elements required to establish the commission of the offense charged, or whether the offenses differ from the offense charged only in the respect that a less serious harm or risk of harm was required to establish its commission. When you're looking at, particularly when you're looking at the offense of rape, but also when you're looking at aggravated battery and criminal confinement, there really isn't a straight-faced argument that these fall on the spectrum of harm. I think that's a really important point here. When you look to, I think the argument as it pertains to rape, the elements are just so radically different from criminal confinement and aggravated battery that it's easy to conclude that those offenses are clearly not the same. But there's more nuance when you're looking at criminal confinement and aggravated battery. But as charged here, because the state specified aggravated battery, the harm we needed to prove was a substantial risk of death, as opposed to in criminal confinement resulting in serious bodily injury, the harm that we specifically alleged was extreme pain. One of those concepts is not included within the other. The conduct by Mr. Young could very well have killed Ms. Silva without ever causing her pain. That was the testimony that we heard. So I think there's a strong argument that there isn't even an ambiguity that as charged, one of these offenses is necessarily included within the other. But if we jump to phase 3 of the Waddle test, which is where Mr. Dillon has sort of articulated his argument, phase 3 is essentially like a cabin version of the old Richardson's actual evidence test. And the cases that the state cited in our memorandum, the prosecutor's closing argument was dispositive in both of those. So in the recent line of cases that have built on Waddle and then subsequently AW, which I think it gives a better articulation of the Waddle standard than Waddle itself does. They were really dealing with a fundamental question of were these two offenses the same crime? And the cases where the courts have concluded that the offenses are in fact the same crime, there are things like that machine gun statute versus, a juvenile in possession of a firearm or a dangerous weapon. There are things where you're looking at aggravated battery and attempted murder. Or I believe it was the completed offensive murder, and if I'm remembering that incorrectly, I apologize. Where you're really only looking at one course of conduct and one action. In that case, it was strangulation for the murder charge. The mechanism by which the defendants in those cases accomplished the greater charge was identical to the mechanism by which they would have accomplished the less serious offense. In our case, the state was very, very clear, and we were as methodical as possible and as precise as possible in the way that we argued the evidence as it was presented to make sure that there were 3 discrete categories of evidence that supported each of the offenses, that if presented alone, if the other charges didn't exist, would have been sufficient to lead the jury to the conclusion that the defendants were guilty of those charged offenses. The evidence as it relates to rape was separate from the evidence as it relates to the criminal confinement SBI, separate from the aggravated battery evidence. So I do believe that the argument made that because these happened within a couple of hours of each other and happened in a common place, I think to conclude that because of those 2 factors, that these offenses were the same crime would really be logically incoherent, and it would produce a result that is essentially manifestly unjust. Where the courts in Waddle and AW, they're trying to bring clarity to double jeopardy. They're not trying to incentivize. They're trying to make sure that the evidence is cabined and presented and argued in a way that's just and fair. They're not trying to incentivize essentially what is like Costco bulk buying of criminal offenses. So for those reasons, Your Honor, we do believe that there is not a double jeopardy issue and that the offenses can be run consecutively by the court. Not mandatorily, it is discretionary. I agree with Mr. Ring on that point. But we are asking that all of these offenses be run consecutively because of the gravity of the offenses and the harm to the victim, and as well as the danger that it exposed to her children. Even though the evidence will have indicated that the children did not interrupt the offense or did not see it, their presence is a significant aggravator. So we are asking the court to sentence to the maximum allowable amount of time. Thank you.
Thank you, Mr. Leong. Ladies and gentlemen, I have seen many things over my more than 20 years of being involved in the criminal justice system. In particular,
Oh, can you guys hear me? I hope you can hear me. It's saying my microphone is working. I think it is. My camera just isn't, period. So you heard from everybody, and now the judge is about to give us tea. She's spilling tea that we heard hints about but had no idea. And it's bad. But I mean, it's not too graphic, don't worry, but it's bad. And then we change our feelings about everybody real quick.
really, as my role as a judicial officer for nearly 10 years, I've had the occasions to preside over cases involving just horrific acts of violence. That being said, this case stands out amongst one of the worst cases that this court has ever seen. And the court was particularly impacted by this, and I certainly don't mean to indicate that I'm callous to other things, but for lack of a better term, you do kind of build some type of tolerance to the depravity that human beings are willing to impose upon other human beings. But this is just beyond the pale. The one thing that I keep coming back to is just how senseless this was, how this makes no sense that this happened. And I can't reconcile in my mind why. Why did this happen? Ms. Silva was living her existence in Michigan with her family, having had no contact with you, Ms. Malott, for years. And but for the fact that you initiated this contact with Ms. Silva and got Ms. Silva to Indiana, this would not have happened. And I can't understand how or why this was ever concocted. And I'll go into a little bit more detail in just a few moments. And I think that just, if nothing else, to help the court organize its thoughts with how to pronounce sentencing, what I would like to do now is focus on the aggravating and mitigating circumstances. And Mr. Young, I will focus on the aggravating and mitigating circumstances for you. While there certainly is an argument that you either have a lack of criminal history or criminal history, you certainly have criminal history that's outlined in the pre-sentence investigation report. And it spans over a fairly long enough period of time that gives the court some concern about whether or not you are going to conform your behavior to being a law-abiding citizen. While I understand you and your attorney disagree with the high rating of you having regarding your attitudes regarding criminal mindset or attitude, I think based upon the information that I've seen that it is appropriate. So as an aggravating factor, I will find that you have a history of criminal or delinquent activity, which is outlined in the pre-sentence investigation report. I will also find, Mr. Young, that the harm, injury, loss, or damage was significant and greater than the elements. I know that it is difficult from the state's perspective when deciding charges to file, particularly when it comes to attempted murder, whether or not a conviction can be sustained, and that can be an incredibly difficult charge to prove. But based upon the evidence that was presented to the jury, I believe that the facts support a conclusion that you could have been charged with the offense of attempted murder. I focus that particularly on Ms. Silva's repeated statements that you and Ms. Malott were going to kill her and kill her children, and based upon the injuries that were inflicted upon her and the way that the offense stopped, not because you chose to stop it, but because the police arrived when the neighbors called the police, that certainly attempted murder would have been appropriate based upon the facts presented to the jury. The court will also find that the crime of violence, this was a crime of violence, and it was knowingly committed in the presence of a child less than 18 years of age. And particularly the crime of violence would be the aggravated battery, as the other two cases are either either two counts are either statutorily or based upon appellate decisions not determined to be crimes of violence. We had children that were in the home, a child who was 4, autistic, nonverbal, and a child who was 2, that presumably had limited verbal skills just by nature of his age, that were there in the home. And the fact that we had neighbors on the other side of the wall who couldn't sleep because the screams of Ms. Silva and the beating was so loud that they could hear it, the court presumes that the children could hear it too. And I'll just make this comment because, I recall when my children were little and seeing an advertisement for a fire alarm, that there are actually fire alarms that are developed specifically for children because children often will not wake up to the sound of a fire alarm, but what they will wake up to is the sound of their mother's voice. And it would not be a stretch of the imagination to believe that hearing one's mother screaming and pleading and begging for her life, begging for the life of her children, and begging for mercy was not heard by these children. So the court finds that to be an aggravating factor. Mr. Young, the court will also find that other forms of sanctions have proved to be unsuccessful in keeping you from engaging in criminal activity. As I've indicated, your criminal history spans, and let me just go back to the pre-sentence investigation report in your case so I can accurately reflect the span of that criminal history. So I'm focusing on page 4 first. So your first involvement with the criminal justice system was in 2013. And your criminal history then carries over to the next page, full page. You have had opportunities to complete your sentences in the community, and that has not curbed your behavior. The court will also find that you have not taken advantage of programming or alternative sanctions offered to you in the past. Again, that is reflected in the fact that you have been placed on community supervision and it has not curbed your criminal behavior. I will also find that there is a non-statutory aggravating factor in that there is uncharged conduct here. Mr. Young, I don't know whether you actually uploaded the videos that were presented as evidence to the jury, or if you provided those to another person or persons, and those persons then uploaded the videos to social media. But regardless, the only way that that could have happened is if you facilitated that. So certainly you could have been charged with disseminating the video. That would have been a violation of Indiana law. Turning now to mitigating factors. Mr. Young, while you today accept remorse and you express to Ms. Silva, and I think that the state characterized it as something as though you're sorry that this happened to her, I agree with the state. The fact that you're using a passive voice suggests that this just happened to her without you being involved. It takes away from any acceptance of responsibility, again, what I just referenced regarding this video that you had to have either uploaded yourself or sent to somebody else after the fact. I cannot fathom what was going through your head and why you would have thought that that would have been appropriate to have sent that to anybody. Either you thought that it was funny, or I don't know what else, Mr. Young. I don't know what you would have been thinking and what benefit could have been gained in any way, shape, or form by providing that other to just further humiliate and victimize Ms. Silva. As far as any other mitigating factor, I will give you this mitigating factor, Mr. Young. I will give you the mitigating factor that imprisonment will result in undue hardship to your dependent children. You had a history of being gainfully employed. I presume that you were, even though not ordered to do so for most of your children, that you were providing at least some support, whether it was direct support or in-kind
Thank you so much, Donald. Thank you. I appreciate it.
support. I believe this is going to be a hardship on your children, that imprisonment will make it unlikely that they are going to receive any further financial support from you during that period of incarceration. When the court weighs the aggravating and mitigating factors, the court believes that the aggravating factors far outweigh the mitigating factor that was found by the court. And as such, Mr. Young, the court will sentence you to what was requested by the state of Indiana. That would be 36 years at the Indiana Department of Correction. And let me spell out how that will be applied. So as to count 1, attempted rape as a level 3 felony, and count 2, criminal confinement as a level 3 felony, the court agrees with the state that there is a cap as far as the sentences are concerned. So on attempted rape as a level 3 felony, I will sentence you to 4 years at the Indiana Department of Correction. I will award you credit for 268 days served plus statutory good time credit. And then consecutive to count 1 and count 2, criminal confinement is a level 3 felony. I will sentence you to 16 years at the Indiana Department of Correction. Again, I will award you credit for 268 days served plus statutory good time credit. So again, it's a 20-year cap on counts 1 and 2. However, the court is not bound by that cap on count 3, aggravated battery, as that is a crime of violence. And again, the court has found that the aggravating factors far outweigh the mitigating factors. So on count 3, aggravated battery is a level 3 felony. The court will sentence the defendant to 16 years at the Indiana Department of Correction. There is no credit to award against that sentence, as the court has already awarded the credit time in counts 1 and 2. And before I lose sight of this, the court agrees with the state of Indiana that Wadle is the appropriate case to do the analysis.
Wadle, yeah, that's what I was saying, Wadle. Anyway, they were arrested September of 2024, and they've both been in jail since then on this case. I don't know when it actually happened. I just know, I think they were arrested that night. The neighbors in the duplex heard the screaming for hours and hours from Miss Silva, and finally called the police. They were going to kill her. They were going to kill her. They kept telling her they were going to kill her and her children who were there. But the neighbors finally got tired of the screaming and called the police, and I think they're arrested that night. That means it happened September 2024. And we just heard her lay into the dude. We haven't heard her lay into her yet. What this judge is about to say, what this judge is about to say to this woman makes me just pissed off that I didn't get the trial, but I really don't want to watch this trial. There's nothing about this trial that makes me want to watch it, except what the judge is about to say about this monster.
As far as whether or not there is a bar of running any of the counts consecutively regarding the facts that were presented. The state, from the outset of its presentation of evidence, clearly and continuously and consistently articulated different facts to support each count that was put before the jury. Frankly, Mr. Leong and Ms. Rich, the state was masterful in how it presented the evidence and compartmentalized the facts to support the different charges. And I will just touch on those for appellate purposes. So for the criminal confinement, the state had argued, or actually presented evidence in their opening statement, and then argued in closing and presented evidence accordingly in between, that the criminal confinement began when Ms. Silva was restrained by Mr. Young, and they argued there was a large handprint bruise on her shoulder that started that, and that there were injuries that began at that point in time. As the state indicated in its sentencing memoranda, the incident is believed to have lasted longer than an hour. The court does not believe that it was one continuous episode of criminal conduct, as there were breaks in time with some of the incidents that happened. As far as the aggravated battery, the state presented evidence through a number of witnesses and in the video itself that the strangulation incidents were what supported the aggravated battery. So we had, for the criminal confinement, the beatings; for the aggravated battery, strangulation. As to the attempted rape, there was a break in the events between the two recorded beatings that Mr. Young recorded himself, that I think everybody, or at least the state, presented facts to the jury that Ms. Malott had walked away at that point in time when Ms. Silva's shorts, and whether she was wearing underwear or not, I think is really irrelevant, but she was stripped down naked from the waist down at that point in time. So there certainly was a break in time. These are not included offenses. And so really, I think the only consideration under the Wadel test is whether or not the state presented facts and argued to the jury whether or not these were separate and distinct pieces of evidence that supported each claim, and the court will make such finding. The court will order that, Mr. Young, you have no contact with Ms. Silva, either directly or indirectly. I will order that you submit to a DNA sample at your own expense if required. I will impose the mandatory court costs only. No additional court costs will be imposed. Mr. Young, I will go ahead and review with you your appellate rights right now. Sir, you have the right to appeal the sentence imposed herein as well as the conviction. In order to do so, you must file either a notice of appeal or a motion to correct error within 30 days of this date. If you choose to file a motion to correct error, you must file your notice of appeal within 30 days of the court's denial of your motion to correct error. Failure to...
I was waiting for that word this whole time, and they don't say it. Of course it was premeditated. He even says it. Well, not exactly. You'll hear.
Comply with these requirements will result in the forfeiture of your right to appeal. You have a right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you are unable to afford an attorney, I am required to appoint one to represent you at no cost to you. Mr. Young, do you wish to appeal your sentence and/or your conviction?
Yes, ma'am.
Sir, do you have the ability to hire your own appellate counsel?
Okay.
Mr. Young, do you have any income right now?
Okay.
And I believe the only asset that you may own of any significant value would be your home, is that correct?
Yes, ma'am.
And if I also understand correctly, your fiance and children live in that home?
Yes, ma'am.
Do you have any substantial equity in that home such that you can use to hire an appellate attorney?
No, ma'am.
Mr. Young, do you own your semi?
It's already been sent back. I do not.
It was repossessed, is that what I'm hearing?
Yes, ma'am.
Do you have any other business assets left?
No, ma'am.
Based upon your testimony, I will appoint the Office of the Public Defender's Office to represent you for appellate purposes.
Great. All right. The people of the state of Indiana get to pay for his lawyer. Isn't that lovely? Oh, I would be mad if I paid taxes in that state. I do have bad news about this judge, though, guys. So, back when I first found this courtroom, I never ever I got like one case from it, maybe. I don't know. I didn't like it because it's just so dark and foreboding, and it looks like, like uh, it looks like a court right from hell, like you're in the middle of hell because it's so dark. But then we started to like this. Then I started to get more of her, and we started to like this courtroom. Now I'm in love with this courtroom. I just love it. I love it so much. Well, September, they're moving to a new courtroom. They're building it right now. So I have a couple clips from, the last week or so of her that I haven't shown yet, that I will show. But after that, it'll all be in a brand new courtroom soon. And I'm pretty sure it'll be bright and professional and not anything like this. I might have been too.
Turning now to Ms. Malott. Ms. Malott, I find your behavior in court today curious. And here's why I find it curious.
Here we go.
You are clearly tearful today. I don't know if that's genuine or not, but I compare your demeanor today with your demeanor at trial. With the setup in court, it's much more difficult for me to see Mr. Young, but I had a very clear sight of you throughout the entire trial. And to say that I found your behavior during trial to be bizarre would be an understatement. Ms. Malott, you were almost giddy throughout the entire trial. You sat with your legs propped up on the table the entire time. You had just a smug look on your face. When I watched you watching the videos that were presented, again, that left me shaken, you almost looked like you were on the edge of your seat watching a blockbuster movie with enjoyment on your face. It was troubling. It was troubling. And the other thing that the court found troubling is that when Ms. Silva took the witness stand, and as she left the witness stand, you stared her down as she left the witness stand, turned your chair around, and stared her down until she walked out that door. Not only did I notice it, but the jury noticed it, and they were offended. You saying that you're remorseful here today also is inconsistent, not only with your behavior in court for the trial, it's inconsistent with the evidence that was presented by the state of Indiana regarding your recorded phone calls with, I'm not sure who the one person was, but also your grandmother, where you stated over and over again, Ms. Silva was lying, she was faking her behavior in court. You also over and over characterized the video that was presented to the jury as clearly, from your perspective, a mutual fight, which flies in the face of common sense. It flies in the face of what we actually saw. There was nothing even about that fight. And I think you also complained that there were other parts of video that weren't shown. I don't know what that is or could have been, but it's just not true, Ms. Malott. And Ms. Malott, you seem to want to portray yourself as the victim here. I want to also talk about the fact that prior to, and I keep talking about the videos, and when I say the videos, and when I've been saying the videos, I'm referring to the videos in which you were mercilessly beating Ms. Silva in the face, strangling her to unconsciousness, and absolutely ignoring her cries for you to stop, to let her go. I compare that with the other video that was presented before any of this happened, where Ms. Silva is begging you to forgive her for some so-called insult that she committed in your home, which caused Mr. Young to leave the home. And I think it would be important to talk about this. I don't know what the nature of your relationship is, other than just twisted, sick, just completely dysfunctional. Mr. Young, you bear all of the characteristics of the domestic batterers who come before this court in terms of manipulation. So there are a series of events that were presented to the jury, which the court heard. So first, Ms. Malott and Ms. Silva get to the home, drinking, taking photos, sending them to you. You show up. There's some sort of incident where Mr. Young, you get upset and you leave. You engage in text messages with Ms. Malott where you are upset with her because she's not paying enough attention to you. I think that you even said F you to her at one point in time until she's begging and pleading for you to come back, which is exactly what you wanted. You wanted her to be in that subservient position and do anything to make you happy. But in order to get him back, you had to use Ms. Silva for that because you were desperate. You're desperate to get him back, and you would have done anything to get him back. You would have done anything to show him that your attention was focused on him. Mr. Young, apparently you thought you were there maybe for a three-way, is what you told the police officers. Ms. Young, Ms. Malott, I don't know if that was in fact the case, and you were upset about that, and that's why you were beating Ms. Silva. I don't know, because it doesn't matter, because you cannot rationalize this. You can't make any sense of this. But part of what I think fueled this is your really sick and unhealthy relationship the two of you had with each other. It's just beyond my comprehension. So turning back again, Ms. Malott, to your sentencing. As far as the aggravating and mitigating factors are involved, I'm going to make the finding of an aggravating factor that you do have a history of criminal or delinquent activity. You do have that one offense of operating while intoxicated, and I think it is important to focus on the timeline here. So that incident, I believe, happened on July 24th of 2024. Then fast forward to September 4, 2024, where you in the DCS report indicated that you had been following Mr. Young around because you thought he was cheating on you. And then you end up in a parking lot, I don't know if it's Walmart or where it was, in which you left your children unattended in the vehicle that prompted the calling of authorities. And when the authorities arrived, well, I'll touch on that here in just a little bit, but that was September 4th. Then we have this incident on September 22nd, 2024. So within a fairly compressed period of time, we have an escalation of behaviors. You indicate that you're not much of a drinker. I don't know whether that's true or not true, Ms. Malott, and I think it's really irrelevant. But clearly, something triggered your criminal behavior on July 24th, and it escalated. So I will find that to be an aggravating factor. The court will also find that the harm, injury, loss, or damage was significant and greater than the elements. As I indicated in Mr. Young's case, based upon the evidence that was presented to the jurors, I believe that there is a probability that they could have made a finding for a charge of attempted murder. So certainly, again, I believe that the harm, injury, loss, or damage was significant and greater than the elements. The court will also find as an aggravating factor, this was a crime of violence and it was knowingly committed in the presence of a child less than 18 years of age. And specifically in your case, that crime of violence was aggravated battery. Ms. Mallott, you're a mother. You're a mother of an
Okay. She's about to say you're a mother of an autistic child or an autistic son. So, autistic son. So, when I first heard the attorney questioning her, I felt so bad for these children, like being split up and being away from their mother, especially, since the autistic son only knows her, and it must be really hard. Well, the judge is great. Here we go.
autistic child. You also claim to be a victim of domestic violence yourself, and your children have witnessed this. Who better would understand the impact that this would have on not only that child, but the other child that was present regarding this? You apparently had zero regard whatsoever for these children and how they may have been impacted by this incident. And I just can't fathom how the children would not have been able to at least hear what happened. You've heard me say what happened or why I believe that in Mr. Young's case, and I will apply that finding to your situation as well. As far as mitigating factors, Mr. Young, I agree with you. I don't think it's appropriate to say, she made her choices, and because she made her choices, that it's not appropriate to find a mitigating factor regarding imprisonment will result in undue hardship to her or her children. But I think looking at the specific facts of this situation and looking at, again, the fact that the children were not in your care and custody and that this incident occurred, leads the court to the conclusion that you are not entitled to that mitigating factor, Ms. Mallott, and here's why.
Six children heard this.
I was starting to touch on this, the DCS report that I very briefly reviewed, because again, I did not review it prior to today because I didn't want to do that without permission to do so. But the little bit that I did read, Ms. Mallott, when law enforcement made contact with your children, they described your children as being filthy, the car being filthy, multiple dirty diapers, filth, rotten food. One of your children had scratches on his face. I know kids get scratched up, so that in and of itself would not have been a concern, but everything in its totality was certainly a concern. Here's the other thing, Ms. Mallott. I also cannot wrap my head around the fact that, okay, you have your children removed from your care on September 4th. September 4th. And you claim to care so much about what is happening with these children. Rather than, I guess, doing everything in your power to get your act together, you decide you're going to have a house party, as you characterize it, by contacting Ms. Silva, who was minding her own business in Michigan. Contact her, bring her over, bring other people over. All of that together does not indicate to the court that you are a person who was focused on what was in the best interest of your children. You say here today that you have to get to your children because the people who are caring for them either don't want them, or I think you've provided various reasons why none of the caretakers want these children. It would be pretty darn easy if they didn't want them to just not step forward and not tell the court, I'm willing to take these children and jump through all the hoops that I have to jump through in a Chin's case. If they don't want them, they could be out right now. It is your statement to the court, your assertion that they don't want these children, but I have no other evidence to that effect. You also claim to have been involved in an abusive relationship. Ms. Mallott, I don't know if that's true or not true. If you're the victim of domestic violence, that's terrible. And I believe that it's already been indicated, I think by Ms. During, that there was abuse in your relationship with Mr. Young, which I think some of the evidence presented at trial does support that, Ms. Mallott, that you were definitely under his control. But I think you were under his control as a willing participant. You would have done whatever Mr. Young would have wanted you to do. maybe even including contacting a person that you hadn't had contact with in over a decade, bring her to Indiana to do, God only knows what the intent was, to bring her down. But the choices that you were making, whether it was drinking and driving, getting yourself involved in the criminal justice system, having your children removed from your care because you're so busy chasing Mr. Young around to try to figure out what he's doing and not caring for your children properly, having a house party where you bring in this third party, beat the ever-loving snot out of her, and none of this indicates to me that your children were in your mind. And in fact, I think that one could reasonably conclude that your children would be better off without you, whether they're in the care of family members or strangers who hopefully provide these children with the care and love and support that they desperately need and they deserve. So again, the court finds that there is no existence of mitigating factors. And again, I've already talked about the fact that while you express remorse today, it's completely inconsistent with all of the other information. So I'm not going to give you the mitigating factor that you have taken responsibility for your actions. Ms. Malott, I think to give you anything less than the maximum sentence would be an affront to justice here. It is this court's conclusion that you are a dangerous person and that removing you from the community for as long as the court possibly can is the only assurance that this court has to keep the community safe from your complete depraved behavior and lack of regard for another human being. It appears from the court's perspective, but for the grace of God and the wises, this could have been a much different outcome, and thank God for the wises for intervening here. So the court, based upon the significant finding of aggravating factors on count 1, the charge of criminal confinement as a level 3 felony, will sentence you to 16 years at the Indiana Department of Correction. The court will award you credit for 268 days served plus statutory good time credit. And consecutive to that count 2 aggravated battery as a level 3 felony. The court will sentence you to 16 years at the Indiana Department of Correction. There is no credit to award against that sentence as the credit was already applied to count 1. I will order that as a term of your sentence that you have no contact with Ms. Silva, either directly or indirectly. I will order that you submit to a DNA sample at your own expense if required.
She can't pay for it. She's in jail. I just see, this is why I couldn't be a judge. How did she get through that without swearing? Not one swear word fell. I would be frothing at the mouth swearing at both of them. Anyway, that's why I couldn't be a judge, because you're not allowed to swear. Although some do, but not many, and definitely not women.
I will also order that you pay the mandatory court costs only. Before I do the appellate rights, one thing that I forgot to mention in Mr. Young's case, Mr. Young, one of the reasons that I ran the aggravated battery case consecutive to the other cases is in the video that you recorded and you made available to the public, whether directly or indirectly.
Idiot.
You made the comment to Ms. Malott that you choked her to sleep. While you tried to claim on the witness stand, oh, no, I know I said that, but really I didn't do that. I was just trying to do anything to keep her calm. The evidence would suggest otherwise. So while I understand, Mr. Dillon, your argument is that your client is guilty only by accomplice liability, the evidence presented indicated that you, in fact, individually committed the act of strangulation at least once, if not more, that leads the court to the conclusion that it is appropriate to run that count consecutively. Ms. Malott, I will turn now back to the appellate rights. You have the right to appeal the sentence as well as the conviction imposed herein. In order to do so, you must file either a notice of appeal or a motion to correct error within 30 days of today's date. If you choose to file a motion to correct error, you must file your notice of appeal within 30 days of the court's denial of that motion to correct error. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have a right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you are unable to afford an attorney, I am required to appoint one to represent you at no cost to you. Ms. Malat, do you wish to appeal your sentence and/or conviction?
Yes, I wish to appeal.
And Ms. Malat, do you have the ability to hire your own appellate counsel for that appeal?
Yes, I already have her hired.
Okay, Ms. During, is that you or?
That would be me, Your Honor.
Okay, so Ms. During, I know that you
He had 2 counts of attempted rape. That's why he got more.
will timely file the notice of appeal on Ms. Malat's behalf. And I should also mention that the court, I think I discussed only in Mr. Young's case, the court's analysis of the double jeopardy issue. The court will incorporate that finding of the double jeopardy issue in Wadle and its progeny to Ms. Malat's case as well, and determine that, again, the court finds that the state very thoroughly worked to separate the facts of the case, and the same facts were not utilized for the injuries in the 2 counts. Mr. Dillon, is there anything else that we need to address from your perspective?
No, Your Honor.
Ms. During, anything further? Mr. Leong? Ms. Rich? The court will show that, at least for the trial purposes, the appearances of Mr. Dillon and Ms. During are withdrawn. Any future hearing dates are vacated. The court will confirm judgment of conviction that was already entered, and the court will show that the defendants are remanded to the custody of the sheriff to serve out the balance of the executed sentences.
So my camera doesn't work, so we got to say goodbye like this. Guys, thank you so much for coming to this special live on our day off. I appreciate it. I really, really, really do. Sorry it was so dark, but I, you know, it was, the judge is great. The judge is just amazing. So I had to show her. I hope you guys have a great Saturday. And I hope if you're working, it's very busy. If you guys don't know what to do today, go visit a local brewery and tip your server. Thanks, guys. I'll see you again real soon. Bye.